Today's webinar is entitled Business Travel, Immigration, and COVID-19, the Impact of the Latest Presidential Proclamation, and is brought to you by the European American Chamber of Commerce of Greater Cincinnati, in partnership with the Cincinnati USA Regional Chamber, the Midwest USA Chinese Chamber of Commerce, the Cincinnati USA Hispanic Chamber, the Japan America Society of Greater Cincinnati, and the Northern Kentucky Chamber of Commerce. I'm Todd Schwartz, Executive Director of the Cincinnati chapter of the EACC, and I will be your host and moderator for today's event, for which we have over 250 people registered. One quick disclaimer, please note that all comments and opinions presented by our speakers today are their own and do not necessarily represent the views of the European American Chamber of Commerce, our members, or our partners in this event. We're very grateful to have with us Matthew Wagner and Katie Collier from Frost Brown Todd. Today, they're going to be sharing their expertise and answering your questions. And to help Matthew and Katie calibrate their presentation, we have two quick poll questions to get started, and I'm going to post those now. The first question, as you will see, is how familiar are you with business immigration issues? Let us know if you would say that you're a beginner, intermediate, advanced, or expert on these topics. And then the second question is, which visa category affected by the June 22nd Presidential Proclamation is of greatest interest to you? The four categories that were mentioned in the order were the H-1B specialty occupation workers, the H-2B seasonal unskilled workers, J-1 temporary exchange visitors, certain categories of those, L-1 intercompany transferees. Of course, you may be interested in two or more of these. You can indicate that as well. I'll give you just a minute to continue to vote. But again, as I said, your answers there will help us to calibrate the presentations today to most accurately address your interests. And I see the votes are slowing down, so let's end the polling, and I'm just going to quickly share those results then. I think this gives us a pretty good snapshot. So you should be able to see the poll results right now. Most people can consider themselves intermediate here, about half, with a big chunk also calling themselves beginners on this topic. And overwhelmingly, at least over half of people are most focused on the L1 intra-company transferees, particularly here in the Cincinnati region. That makes a lot of sense. A number of people most interested in two or more of these H-1Bs, J-1s, and H-2Bs in that order. So I think that gives our speakers today a pretty good sense of where we are. And so with that snapshot of our audience, let's go ahead and get right into it. Katie Collier, let's start with you. Could you quickly review our agenda for today? And can you explain the difference between the Visa card in my wallet and the visas that you and Matthew will be discussing today?
Yes, thanks, Todd. So just quickly reviewing the agenda, this webinar will provide an overview of recent disruptions to the U.S. immigration, and that includes recent executive orders and some practical issues such as consular closures and travel restrictions. And I'll provide a quick introduction to some U.S. immigration concepts. So first, as Todd mentioned, what is the difference between a visa in your credit card and a visa that we're talking about today? And then critically, what's the difference between visa and an immigration status? So a visa is essentially an individual's admission ticket into the U.S. So if an individual is outside of the U.S. for any reason, and needs to enter the U.S., that visa allows them to enter the U.S. Like I said, it's very much an admission ticket. In contrast, status provides the individual legal status to be inside the U.S. and legally be present in the U.S. That legal status is governed by an individual's I-94 record. The I-94 record can be found electronically if the individual is unsure where it's located. And that I-94 record expiration date governs that individual's status to legally be present in the United States. They're completely separate concepts. So for example, if you have legal status until 2020 and your visa expires or has expired already, you can still be legally present in the United States. But that being said, if the individual decides to travel, he or she cannot re-enter the United States until they get a new visa. So that legal status, the I-94 governs your ability to be present, where the visa governs your ability to enter. Giving another example, if I am in the United States and my I-94 expires, but I still have a valid visa, that basically means you still need to depart the country. That visa doesn't give you legal status to be in the United States. So once your legal status is expiring, you must leave the US. Another basic concept, which, it's not that basic. People get confused about these issues all the time, so it's very common. The difference between an immigrant and non-immigrant status or visa. So a non-immigrant status or visa is basically temporary. So you're seeking for temporary entrance or temporary work status or temporary legal status, where immigrant visa is that legal permanent resident or green card holder process. So I'm going to briefly cover the April 22nd Presidential Proclamation. So that presidential order basically is very limited. It focuses on the entry of the U.S. aliens as immigrants into the United States. So entry as aliens as immigrants means an individual using an immigrant visa, not a non-immigrant visa, to travel to the U.S. As an immigrant. So this is how individuals outside the United States become green card holders. After qualifying for a lawful permanent resident status and after an individual's priority date becomes current, they can then apply for an immigrant visa, which basically is a travel document to enter the United States as an immigrant. And you can obtain that at a U.S. consulate. These individuals then use that immigrant visa for a one-time entry into the United States, and then they're then admitted as lawful permanent residents. So it only applies to this April 22nd order, only applies to individuals outside of the U.S. who did not have a valid immigrant visa or other travel document as of 11/59 on April 23rd, 2020. It does not apply to existing U.S. permanent residents, EB-5 investors, those coming to the U.S. to work as healthcare professionals, or the spouse or minor children of U.S. citizens. It does not apply to people in the U.S. who are here on temporary status or non-immigrant status. So that's some of the classes we'll be talking about: H-1B, L-1, TN. This particular order does not apply to those individuals. It applies to those who, as I mentioned, are attempting to enter the United States as immigrants. And if an individual is in the United States on a temporary status, he or she can apply to become a permanent resident via adjustment of status. And potentially this, the focus on limiting admission to the United States is likely because the law grants the president some discretion with regard to admissions, but suspending adjustment of status carte blanche probably oversteps his authority. Matt will discuss this a little bit further, but the June 22nd order also extends the April 22nd order until December 31st, 2020. So with that, I will turn it over to Matt to discuss the June 22nd order.
Thanks, Katie. So the June 22nd order is obviously what spurred this webinar, what has created a lot of concern and a lot of angst for foreign national employees and their employers all across the country. There's some things that are clear about the order, some things that are not at all clear. But we want to dive into this and explore what we know and what we think is going to happen with this order and how this affects different people in different situations differently. So what did the order do? Well, the first thing, as Katie just mentioned, the order extended the April 22nd order through the end of the year. That being the order that Katie was just discussing, that limits the possibility of people from outside the U.S. Getting an immigrant visa and coming into the country as immigrants and becoming lawful permanent residents. That's the first thing the June 22nd order did. The second thing is it impacted temporary workers by suspending admission to the U.S. of certain persons in the temporary work authorized statuses H-1B, H-2B, L-1, and J-1. So let's talk a little bit more about what that means and who is impacted. So who is impacted? The June 22nd order affects by its terms people who are outside of the United States and who had no valid visa or other valid travel document. like advanced parole. The third prong is a lot more situational. It's the first two that we are most interested in. So people who were outside the United States and had no valid visa as of the effective date of the order, the effective date being just after midnight on June 24th, 2020. So that's the category of people that we're looking at who the order was targeting. You know, as Katie mentioned at the end of her last slide, the executive has certain authority and discretion to control or prevent people from coming into the country. And, you know, that's premised on the executive's authority and responsibility related to U.S. national security. We want a branch of the government that moves the fastest, that can make quick decisions to have influence over national security in the event that's needed. So the immigration laws give the president a fair amount of authority on that. The immigration laws don't give the president nearly as much authority to impact people who are already here or the terms and conditions of these various temporary employment programs. And so that's why we're seeing these executive orders targeting the admission of people from outside the country coming into the country. So again, looking at people outside the country who have no valid visa. Let's talk really quick about these various categories and what the impact of preventing people from coming into the U.S. in these categories. H-1B, especially occupation workers. This is one of the most well-known temporary employment categories in our immigration system. It's one that comes up in the news a lot. It's one that gets argued about in Congress every couple of years about revising the program for better or for worse. H-1B is the most well-known because it's the most broad. This applies to a wide variety of positions, of occupations, with the general criteria being that this is for jobs that require at least a bachelor's degree in some specific field or its equivalent, and that the employee a company is sponsoring has the relevant degree. So this is used quite a bit for, highly technical engineering and software developer positions. This is used by a lot of IT consulting companies to add to the pool of software developer talent in the United States. And this program has also been a frequent target of the president's during his administration. H-2B was also impacted by the order. H-2B is for seasonal, quote-unquote, unskilled workers. These are essentially jobs that don't require any special skills or education. Most commonly, the H-2B programs are used to staff seasonal resorts, hotels, landscaping companies, golf clubs, etc. So the order also impacted L1, intercompany transferees. We saw in our poll at the beginning of the presentation, that's something that this audience is especially interested in, and I think for good reason. We expected this audience to be made up of a lot of subsidiaries and U.S. field offices of foreign companies. We deal with a lot of companies in that position in our practice here at our firm. And L1s are one of the two categories, the others being E-visas, that are most often utilized by foreign companies with U.S. subsidiaries to transfer key personnel from the foreign operations to help manage or be a key part of the U.S. operations. So as many of you probably know, L1 visas require a parent subsidiary relationship or other affiliated corporate relationship, requires that the U.S. and foreign company be within the same corporate family, that the employee who is being transferred must have worked for the foreign operations for at least 1 year in a managerial or specialized knowledge capacity, and now they're being transferred to the U.S. to work in a managerial, executive, or specialized knowledge capacity. So frequently used to transfer key people, managers, key skills to help build up or run the U.S. operations. J1s are the last category impacted by the June 22nd order. Not all J1s were impacted. There's kind of a grab bag of unrelated subcategories within J1. It's used for a wide variety of activities. The J1 categories that were specifically targeted were interns and trainees. And interns and trainees especially are often sort of used to temporarily fill positions in the United States. There's some flexibility there. And then teachers, camp counselors, au pairs, and summer work travel programs. As for why camp counselors and au pairs were targeted for the wrath of the executive, one can only guess. Okay, so we've talked a little bit about who is impacted, and we're going to talk more here about what that means. But let's talk about who isn't impacted and some of the exceptions here. So who is not impacted is anyone who was in the United States in any one of these categories as of just after midnight, June 24th, 2020, when the June 22nd order went into effect. So anyone who is here in H-1B status, in L-1 status, H-2B or J-1 is still okay to be here, can continue to seek extensions of status that their employer might file with USCIS, can continue to seek changes of status in appropriate circumstances. So the order does not impact someone who is here from, if otherwise eligible, continuing to stay here, extend or change their status. The other group of people who were not impacted would be people who are outside of the US but had valid visas at the time the order went into effect. And I'm going to talk a little bit more about that on the next slide, so let's save that for just a second. What about the people who are here and being able to travel abroad? You know, right now, for reasons that I think are going to become clear as we go through the next few slides, our general recommendation is if you do not need to travel abroad, we recommend you don't, for a variety of reasons. But let's first say, you know, the order should not prevent you from traveling abroad and getting back in. If you were here in the United States when the order went into effect, then you're outside the scope of the order. You should be fine. There's a lot of things that can potentially go wrong, however. One thing is there's a lot of gray areas in the order, which I'll touch on in just a second. We are waiting for some interpretive guidance from U.S. Customs and Border Protection on what the order means, what they think it means, which is what matters the most, and how they are going to interpret and apply the order. The other issues we're going to touch on in a bit. There's travel restrictions, there's consular closures, there's a lot of other things that could impact the ability to successfully travel abroad and get back in. But on its face, the executive order should not prevent someone who is legally here from traveling and coming back into the country. Other groups of people who are not impacted, I think this is also important, especially for businesses to understand and strategize in terms of staffing and talent needs. So F1 university students were outside the scope of the order. That's notable because there was a lot of speculation leading up to June 22nd that F1 university students would be impacted and would be included. So they were not, which is good news. E1, E2 visas, which a lot of foreign companies with US operations are able to utilize. Not all, but a lot of companies can. E1 visas were not impacted, so also good news. TN visas, which come out of the NAFTA treaty and are also incorporated, the TN program is incorporated wholesale into the successor treaty that the US, Mexico, and Canada are in the process of implementing. TN visas also not affected, as well as O1s. So there are still some options available, although obviously the options have narrowed. And I also want to highlight again what I said earlier about changes of status. So H-1Bs took one of the biggest hits with this June 22nd order. Because if you're familiar at all with H-1Bs, you know there's an annual limitation on how many H-1Bs can come into the country, and there's an annual randomized lottery process to see who gets an H-1B visa. So every year, a lot of new workers come into the country for the first time on H-1B visas through the H-1B program. The lottery process happens in April, but the first time those new approved H-1B employees can come into the country is in late September. So they are all dramatically impacted by the order. There's a lot of people who were planning to come here and a lot of companies that were planning to have these employees that they felt they needed. And these employees are not going to be able to come here this year. Those approvals are still valid. So a lot of the hurdles have been overcome. They're not going to have to go through the lottery again, but they're not going to be able to get here in 2021. One of the biggest other sources of H-1B employees is F1 university students who are changing status into H-1B. So again, as we see from the order who's in, who's out, those F1 students who are currently maybe working, after graduation for employers who are going to change into H-1B status, they are not impacted by the June 22nd order. They are still going to be able to change into H-1B status once approved and have a little more certainty about their future for themselves and for their employer. So definitely the impacts are sort of very uneven, for this reason. Different groups of people impacted, people in different situations are impacted. And it's interesting to see how this is all playing out. So I said a second ago, there were a lot of questions and gray areas about the order, about the text of the order, the impact it's going to have. Let's spend a few minutes talking about that. So the first question, are Canadians exempt from the order? Are they subject to the order? The order didn't say anything about Canadians. The word Canada, Canadian does not appear anywhere in the text of the order. The reason we asked the question, are Canadians exempt, is because of how the order is worded. The order says the impacted people, again, people outside the country without a valid visa at the time that went into effect, the impacted groups of people cannot seek entry into the United States, quote unquote, pursuant to a visa. So as Katie told us at the beginning of the presentation, a visa, and by that we mean your visa stamp in your passport. Your visa is essentially your ticket to get into the country. Well, Canadians, somewhat uniquely, do not have to have a visa and are given preferential treatment under immigration laws. So if the order only impacts people who are coming in pursuant to a visa, and Canadians are almost never coming in pursuant to a visa, does that mean Canadians are not impacted by the order? And it looks like the answer is yes. Canadians are not impacted by the order, will be able to continue to come into the United States in H-1B, L-1, or the other impacted statuses. We have already seen some anecdotal evidence of that. Some Canadian employees of our clients who we have been able to get back into the country after the order took effect without issue. And we're now seeing some reports that the anticipated forthcoming Customs and Border Protection guidance, interpretive guidance, is going to expressly say that Canadians are outside the scope of the order. So we think we have a handle on that gray area. Next, what about people with approved work authorized status, have been in the US for a long time, but got stranded abroad when COVID-19 hit? And let me explain a little bit what I mean by that. For most of these statuses, and primarily for this presentation, for this audience, we're talking about H-1B and L-1. For most of these statuses, employers have to seek pre-approval from USCIS to sponsor an employee for these statuses. And then once USCIS has issued an approval notice, the employee takes that approval notice, goes to a US consulate, gets a visa, comes into the country in that status. So, the reason we ask this question, there's people who have been living and working in H-1B or L-1 for many years. They still have valid approval notices. They still have time left in H-1B and L-1 status. They have a job to come back to, but they happened to be traveling abroad in February or March of 2020, unfortunately. And so a lot of people got stranded outside the country. A lot of people were traveling abroad, needed to renew their visas. We're planning on doing that. Normally it's very routine. It's something that can be done fairly easily during travel abroad. And suddenly the pandemic hit, the US consulates closed, no more visas are being issued, and now people are stuck. And now this June 22nd order comes out. By its terms, these people are out of luck. They're not going to be able to come back for the rest of the year, even if they can get a visa. But the reason we are speculating about this is because the rationale of the order about not wanting to have foreign workers come in and compete with U.S. workers for jobs at a time of historic unemployment in the United States, that rationale doesn't really apply to people who have been here for years working in a job and just got stuck by bad luck when the pandemic hit. So we don't know if there's going to be any sort of exception carved out. We don't know if having a valid approval notice is going to create another trigger that puts someone outside of the order. Again, by the plain terms of the order, these people are probably going to be negatively impacted, but we're still hopeful maybe we'll get something from Customs in the interpretive guidance that addresses this scenario. The last thing, what if you have a visa, but it's not an H-1B or an L-1 visa? you know, citizens of a lot of countries are eligible to, well, citizens of most any country can apply for a B1, B2 visitor visa, which is a fairly routine visa used for people just coming for very short-term trips to the US for business reasons or for tourist reasons. And for citizens of a lot of countries, these visas get issued for up to 10 years and are not mutually exclusive with an H-1B or an L-1 visa. So it's conceivable there's a lot of people out there who maybe were outside the United States on June 24th, who maybe don't have a valid H-1B or an L-1 visa, but they have a B-1 visa. The order doesn't specify what kind of visa you have to be exempt. So this is another sort of gray area where the drafting of the order wasn't as precise as we would have liked to see, and maybe there's a potential loophole here where you could renew your H-1 or L-1 visa and still come into the US because you had some kind of visa as of June 24th. But again, this is kind of speculative on our part. We don't know if that's going to be the case, and we are, hopeful we're going to get some interpretive guidance from Customs fairly soon. So with that, I'm going to pass things back to Katie because even outside of the June 22nd order, there's a lot of other things that have been going on and are still going on that are creating disruptions and obstacles for people coming to the United States or traveling abroad and getting back in. Katie's going to talk us through some of that.
Exactly. So as Matt mentioned, there's a lot of, even beyond if you don't fit within one of these executive orders, there's a lot of disruptions that could practically prevent you from getting a visa or traveling. So the first is various consulate closures. Consulates started closing in March and remain closed today. So there's a lot of mixed messages regarding whether they will reopen this year or when they will reopen. Some consulates are accepting emergency appointments only. That is a pretty high bar to obtain one of those emergency appointments. So even if you are outside of this order and you do not fit in this order, it practically means you cannot get a visa right now, and maybe cannot for the foreseeable future, simply because the consulate is closed. So you cannot obtain a new visa if you cannot get an appointment with the consulate. So even if you're in those categories not impacted by either order, which, as Matt mentioned, are B1, B2, F1, E1, E2, O1, TN, you cannot get one of those visa appointments with the consulate to get a visa. So practically that is a huge bar to overcome. As for travel restrictions, that is another large issue that individuals will face. So generally, there's the danger of international travel due to the COVID-19 pandemic as a whole. A lot of countries who you can enter are having mandatory quarantine. So even if you are able to enter a certain country, you may be required to quarantine in that country for 14 days before you can take any action. If you were able to get an emergency appointment at a consulate, you may have to quarantine 14 days before you can attend that appointment. Then there are a number of travel restrictions in place. The U.S. has current travel restrictions in place that provide that individuals are not permitted to enter the U.S. if an individual has visited one of a number of countries in the past 14 days. That includes China, Iran, the Schengen area, United Kingdom, Ireland, Brazil. There are some exceptions to the travel restrictions for certain individuals, such as U.S. citizens, legal permanent residents, aliens who are the spouse of or child of a U.S. citizen or legal permanent resident, and a few other exceptions. So that's another huge barrier to, even if you are able to get a visa, are you able to enter the U.S., or do you have to travel to a third country to wait 14 days to then be able to enter the U.S.? So it's just another practical barrier that has to be overcome to get a visa and enter. There also is the U.S., Canadian, and U.S. Mexican border restrictions. So the U.S. has reached an agreement with both Canada and Mexico to allow travel across the borders, but it has been limited to non-essential travel. As of June 16th, it was extended, this agreement, until July 21st. It has been consistently extended since March. Now there are a few exceptions for immediate family members. And, there are some examples of what's considered essential travel, critical infrastructure, economic services. Generally, we've had some success if you have a duty that requires travel to Canada or Mexico, that may be sufficient. But as I mentioned, a number of countries have those mandatory quarantines. So even if you are able to travel to Canada and then to do what needs to be done, you may have to be quarantined for 14 days and then, your return. Another practical barrier in the EU is set to impose restrictions on the US. As of yesterday, actually, the Council has announced that it's starting to lift certain travel restrictions for certain countries, beginning today, July 1st. Some of those countries include Japan, Canada, it provides China, subject to confirmation of reciprocity, and a number of other countries. Importantly, the United States is not listed on that list. They do review this list every 2 weeks, so it could be that United States residents may be, allowed to travel to the EU on a later date. But as of right now, they are not listed. There are a few exceptions, generally EU citizens and their family members, long-term EU residents, and travels with essential functions or needs. So these are just some practical barriers that even if you don't fit within one of those executive orders that Matt and I discussed, that you will have to face to travel and to potentially get a visa and to re-enter the United States. So Matt's going to hop onto what can we expect next.
So that's a very, very good question, Katie. What can we expect next? At a high level, I recall when President Trump got elected, and I had a lot of clients calling and asking me, well, what do you think is going to happen? And my answer then is, to some extent, the same as my answer now. Your guess is as good as mine. We've seen a lot of changes the past several years. We've seen a lot of changes the past several months in immigration. I do expect that to continue. I expect the idea of change to not go away anytime soon. And unfortunately, that has created a lot of uncertainty for foreign national employees and employers. But, trying to look ahead, there are some things we have seen or heard reports or speculation about, some things we think are coming. In terms of potentially more restrictions, one thing that I think is important to understand is, a lot of these disruptions we've talked about today, started because of the COVID-19 pandemic. The travel restrictions, the consular closures, visa suspensions. But we seem to have entered a phase very recently, and I think especially with the June 22nd order, where some of these changes and restrictions are being less driven by policy around the pandemic and are more being driven by politics and potentially being influenced by the fact that there is a U.S. presidential election going on right now and something we're headed towards very shortly. So politics is definitely playing into this, and that at least I think acknowledging that enables us to try to look ahead and see what else, might be coming down the road. Like I mentioned earlier, there was a lot of speculation F1 university students might have been included in the order. We can only guess as to why they were not. Some of it certainly could be the economic uncertainty a lot of universities are facing, and the administration not wanting to kick universities when they're already down. But at the same time, F1 university students also do, in theory, compete with U.S. workers for jobs. So if that's the administration's biggest concern, we could see some restrictions coming around that. We could see some new regulations coming around that. There's been speculation, well, not just speculation, but announced intentions by the administration for years of eliminating work authorization for the spouses of H-1B employees, H-4s. That hasn't actually happened yet, but we maybe could see the administration accelerate the regulations to make that change. There's also been talk, almost since day one of the Trump presidency, of changing the H-1B program. And one of the ways they've been looking to do this, that's been reported for years, is changing the prevailing wage and making it so that you can't get someone qualified as an H-1B employee unless they are paid on the higher end of the prevailing wage scale and paid, at or above what U.S. workers are typically paid. There was even speculation something like that could be incorporated into the June 22nd order. That kind of change would be complex. It would be more complex from a legal standpoint of what the administration's already done. So the fact that it hasn't happened yet could just be a function of they need more time to implement it. We don't know, but that's something to keep an eye on. We also expect legal challenges to the June 22nd order. There weren't, to my knowledge, any legal challenges to the April 22nd order. But, you know, as Katie kind of intimated, the April 22nd order most deeply impacted families. It didn't fall as much on business personnel for the simple reason that business personnel have a way to get into the country, generally in a temporary status, H-1B, L-1, the things we've been talking about today. And once they are in the country, they can achieve changing into lawful permanent resident status, getting a green card by what's called adjustment of status. And adjustment of status was not impacted by the April 22nd order. So the April 22nd order mostly impacted families outside the country trying to come in and get their green cards. Didn't draw legal challenges, certainly from business groups who were largely not impacted. But the June 22nd order is different. A lot of business groups are significantly impacted. A lot of foreign companies are impacted. This could have an impact on foreign investment in the U.S., which could potentially give, you know, cities and municipalities some standing to challenge the administration's order. So we expect there may be some legal challenges. Of course, legal challenges take time, and at the end of the day, it might be faster to wait and see if indeed there is a change in leadership in the United States in November and then in January. So once again, the only thing we can really expect is that there's probably going to be more change, and unfortunately, there's going to continue to be uncertainty. And we're going to do our best to help our clients and their employees navigate that. The last point to touch on, which I know Katie mentioned, is when the consulates will reopen. We don't know when the consulates will reopen. We expected it to happen by now. You know, the closures happened in late February, early March due to the pandemic. The closures were worldwide, so it wasn't just focused in China, although that was some of the first consulates to close were in China. The expectation was by summer, consulates would be reopening. There were even some media reports in early June that consulates were imminently going to start phasing back into reopening and issuing visas again. That has not happened. And now we are hearing reports and speculation that the consulates may just stay closed through the rest of 2020. Again, thinking about some of these rationales are shifting perhaps from pandemic motivations to political motivations. But again, that may help us at least try to anticipate what's happening in the future. So with that concludes the substance of the presentation. We did want to save some time for questions. It looks like there are quite a few questions. Todd, are you going to moderate this, and do you?
Absolutely. Yep. First of all, I think the first thing to say again is just thank you to Katie and Matthew for this really, really informative presentation. There's so many issues that are left unresolved there. Katie, I'm going to take that. Hopefully you've got Katie and Matthew's contact information there. I will, Katie, if you can take that down, we can go to the Q&A so people can see you guys, because I want to do that. We will share the slides with the audience. We'll send that out as a link with the videos when that is ready. But yeah, let's go ahead and get some of these questions. A lot of the questions, I think there's a number of questions we're not going to be able to answer because they're outside of the scope of the presentation, but let's just get into it. First question that came in: as a valid L visa holder currently in the United States, is it better to stay in the United States until new guidelines are issued by the Customs and Border Protection, or is it okay to go out of the United States and re-enter based on the current U.S. CIS guidelines? I mean, assuming somebody's going to travel outside the United States, which of course is not necessarily recommended for any reason, how would you respond to that?
Well, that's right, Todd. I mean, I said at some point, you know, we're generally recommending against travel if at all possible, but sometimes it's unavoidable. And I've had a number of clients since the June 24th or June 22nd order need to travel abroad. So I know that has to happen, and people have to deal with that. If you can wait for the interpretive guidance from Customs, I think that would be better. So we have a firmer grasp of how Customs is going to handle these issues, because at the end of the day, that's what matters the most. You know, I can tell you what I think all day long, but I'm not a Customs officer who's going to decide whether or not to let you back in. What I can say is if you are already here and your visa stamp in your passport is still valid and unexpired, you should be able to travel abroad and get back. You need to be aware of the travel restrictions. So for example, if you're traveling to Europe, you may need to travel to a third country for 14 days before you can come back to the United States. But in theory, you should be able to do this. One thing we've been doing to help try to give some of our clients peace of mind is preparing travel letters sort of explaining precisely why this person is outside the scope of the executive order and ought to be admitted back into the United States. So again, we'll see how that goes, how much value that has, what Customs thinks about this. But from our reading of the order, it only applies if you were outside the U.S. at the time it went into effect. It's not sort of a rolling, criteria where once you depart, suddenly you're swept up in the order.
Yeah, and someone asked a similar question regarding the e-visa. Again, as a valid e-visa holder, is it just better to stay in the United States? I think, again, the answer there is probably yes, for all the reasons that you stated. If you leave the U.S., it's just unclear if you're going to be able to get back in, regardless of the legal status. It's up to the immigration officer to make that determination. A couple people have pointed out that there was a new amendment to the Presidential Proclamation. Do you have any comment on that, particularly as it relates to maybe B1 visas or other visas?
I know some guidance came out last night. We weren't prepared to talk about that in the presentation today. We haven't had it yet, so I don't want to comment prematurely and say something.
Fair enough.
That I might not agree with later on.
Let's see. There was a couple of questions that came in regarding ESTA and also some of the other elements. Does this have any impact on the ESTA agreement?
It shouldn't. No. So ESTA is a visa waiver program. An ESTA card is a travel document that is not technically a visa. It is only available to citizens of certain countries. Again, the plain language of the order in terms of it applies to people entering pursuant to a visa. Well, ESTA is not a visa. ESTA would put you outside the scope of that language. And also ESTA is not within any of the categories that the order applies to, H-1B, L-1, J-1, H-2B.
Okay. Question came in about someone who is a Japanese citizen who working with a U.S. company on an e-visa, but for the last couple of years the person has been in Mexico. Would they be able to renew their e-visa under these regulations?
Well, the executive order Matt spoke about, the June 22nd order, does not apply to E1 or E2 visas, but that's really getting on the practical issues that may arise of, one, can you get an appointment at a consulate to renew the visa, and then two, any sort of travel restrictions that may inhibit you from traveling where you need to travel to get that visa and then re-entering the United States.
Thank you. Question, and I think you addressed this. Somebody asked about the status and restrictions for European employees coming to the United States for short projects and meetings. I mean, it sounds like that would be a B1 visa. And as you've mentioned, that would not be covered by this executive order. However, that travel would be blocked by the restrictions on people from the Schengen countries coming into the United States. I mean, are there workarounds beyond that kind of 14-day quarantine, sort of self-quarantine in a third country that you guys have explored?
I mean, there's exceptions, but our understanding is they're very difficult to get, and they're not really being granted. So no, I mean, the only workaround I'm aware of is that the travel restrictions are phrased such that you can't come in if you were physically present within one of the Schengen area countries in the past 14 days. So if you're able to go somewhere else, another third country that will accept visitors from Europe, stay there for at least 14 days, and then try to enter the United States, then you can truthfully say, I have not been in Europe in the past 14 days. I've been in Mexico, I've been in Canada, again, if Canada will accept you. I've been somewhere else that's not currently restricted by the CDC travel restrictions, and then you should be able to get admitted.
Right. And just a reminder, of course, that relates to that's not a question of nationality, that's a question of physical presence. So if you're Japanese and you're in Europe, you cannot enter the United States unless you've had that 14 days. Just a quick anecdote, it's my understanding that the new head coach of FC Cincinnati, Jaap Stam, who was traveling from the Netherlands and had to take that 14-day quarantine. I don't know where he spent it. I hope that it was someplace like the Bahamas or British Virgin Islands or someplace nice, because I want him to be well rested for our soccer team. I just want to share one question here that I think is interesting and kind of encapsulates all of this and expresses the frustration. And I don't think there's really an answer for it, but someone has written, we're a global business. We've made a major investment in a second location in the United States. They're the only made in USA manufacturer of the product. They have gotten e-visas for 3 of their employees in Europe, which is where their global headquarters are. But of course, they cannot bring these 3 key employees to the United States. They've worked with attorneys, they've worked with the embassy, they've worked even with the Senate, with Senator Portman's office. They can't get a waiver. And this is really handicapping their business. And on top of that, the extended unemployment benefits are making it hard to grow their business, to hire the workforce that they need. Again, a kind of a rhetorical question, but clearly this is going to have a chilling impact on growth of foreign investment in this region and across the United States. Do you want to maybe just comment quickly on that?
I completely agree, and I feel that we are in unprecedented times, and a lot of companies are facing unprecedented obstacles. In terms of the immigration obstacles and disruptions, again, I sadly, I think some of this is politically motivated. And were we not in a campaign year? And perhaps were the president not in a campaign where he is not doing well in current polling? Of course, anything can change very quickly. But I wonder if we would have seen these restrictions. I wonder if these would have been put into place. But this is an issue that the president, I think, feels plays to his base. And he is trying to make sure his base shows up in November. And so this is something that we all now have to deal with. Even if it negatively impacts business, negatively impacts foreign investment, this is the world we are currently living in. All we can hope is that it changes for the better sometime soon.
And of course, not to add to the frustration, but one question asked pointed out that, the Customs and Immigration Service, which of course is largely funded by fees that are paid by importers, that they are facing the potential furloughs of 13,000 employees, which of course is only going to further delay any kind of reopening and processing of some of these documents. A question, a little bit digging into an issue, a little bit beside the scope here, but an interesting question. E2 visa reciprocity with France. Someone has asked about the E2 visa reciprocity used to be 5 years and has currently been limited to 6 months. Does that sound correct? I don't have the reciprocity tables in front of me, of course.
I don't either. I'm not sure. In the reciprocity table, that's something that the Department of State, that at their discretion, they can change at their discretion. So I'm really not sure off the top of my head, but I mean that's something that the executive branch does have a fair amount of discretion, changing and limiting that. They're generally supposed to kind of get that public and announce it. It's not supposed to be sort of something they change from minute to minute or case by case, but they can sort of make a shift there when they want to.
Fair enough. Another question about ESTA. So the question is can an L1 visa holder enter the United States using ESTA? I'm assuming that would not work, correct? I mean, if they currently have an L1 visa, I suppose they could actually.
Well, if you had a current L1 visa, you could enter using your current L1 visa. The orders both really impact those who don't have a current non-immigrant or immigrant visa. So if you have a valid visa, you are able to enter the United States. It really just impacts, your hurdles then become, again, those travel restrictions and, I guess in this case, just the travel restrictions. But if you have a valid visa, you are allowed to freely enter the United States, as long as you maybe potentially have to do that 14-day quarantine in a different third country to allow you to enter the U.S.
The other thing I would add there, in trying to maybe read between the lines of the question, the June 22nd order has a provision in it that says anyone who attempts to circumvent the order by fraud or making misrepresentations will, quote unquote, be a priority for removal or deportation. Removal is the kinder, gentler term we use now. Generally, we're not going to recommend that anyone try to enter on some other visa and then maybe change back into L1 status or H1B status. That could create problems for them.
Excellent question. A very important question, I think, more important for this region than people might recognize. What about temporary migrant farm workers? Are they impacted by any of these orders? Particularly coming from Mexico?
No, migrant farm workers generally fall under the H2A category for agricultural workers. Again, we talked a little bit about H2B. We didn't spend a lot of time on it, that being quote unquote unskilled seasonal workers. Essentially H2B is non-agricultural, H2A is agricultural workers. So H2A workers were excluded. And also the June 22nd order contained an exception for anyone who works in a position that is, I forget the exact phrasing, but it's critical to the national food supply or food chain supply. So I think the intention there is that there's maybe a perceived, at least by the administration, or maybe there's a real shortage of workers working in the nation's food supply, working in agriculture. They don't want to mess with that. They expressly wanted to carve that out. So yeah, H2A workers are still business as usual for the time being.
I've seen a few questions about extensions of I-94 in the U.S. I just want to touch on that briefly because that is an important point. So even if an individual doesn't have a valid visa, that gets into the difference of visa versus status. If an individual is in the United States, you can extend their I-94 in the U.S. if you're, depending on what status you're in, and if you're otherwise allowed, if you're not, for example, maxed out. You can extend an I-94 while the individual is in the U.S., depending on the status.
And would you recommend that people try to do that rather than travel outside, try to get a new visa and come back or renew their visas?
Yes, just for the practical reasons. I mean, it would be extremely hard to complete that than all the having travel restrictions. Whereas here, we're able to get an extension in the United States. Your status will be suspended and you'll know legally in the US.
Fair enough. Makes sense. Clearly, we're not going to be able to get to answer all of the questions. Let me just put this last one. I think we've already touched a little bit about this, but again, somebody arriving from Europe or from the Schengen area who goes and was able to spend 2 weeks, let's say in Canada or Mexico, would be able to enter the United States at the end of that sort of self-quarantine time, presumably, correct?
Well, if they have a valid visa already, or if they're coming in under a category of the order, but yes. Now, for a lot of the pandemic, Canada was not accepting non-Canadian, non-U.S. nationals. They have started to ease some of their border restrictions, so that may be an option now. But that's the key, is finding a third country that will accept you from Europe or from whatever country you're coming from. If you're on the travel, if you're coming from a country that's on the travel restricted list, hanging out in the third country for 14 days, then trying to enter the United States. But you've got to think about the travel restrictions. You've got to think about the order. Does that apply to you? You've got to think about if you need a visa, are you going to be able to get one from the consulates? There's just a whole bunch of interlocking obstacles now, like we as we tried to kind of illuminate and show the bigger picture here. But there's a lot to think about, and most of this stuff wasn't even something that existed 6 months ago. So the game has changed quite a bit, and things are definitely more complex than they used to be. And we'll all keep our fingers crossed that we can get some more certainty and some positive changes in the future.
Well, and I think with that, Matthew, you've kind of summed up the central point here, which is that while we can talk about the presidential proclamation from last week, you also have to put it in the context of the April proclamation and the CDC guidelines and the funding cuts and. I mean, these are extraordinarily complex and challenging issues. Obviously, at a very complex and challenging time for our country and indeed the world. So, we are obviously very, very grateful to have experts like you and Katie to help us guide ourselves through this, to help our companies in particular manage these challenges. If you don't have a good immigration lawyer on your side, I can recommend two. And others at the Frost Brown Todd firm, or there's of course other companies and attorneys who are very experienced with this. But as I said, we're not going to get all of the questions answered. We're going to go ahead and wrap up. Let me again say thank you to Matthew Wagner and Katie Collier for their guidelines, for their assistance with today's presentation. That concludes our webinar entitled Business Travel, Immigration, COVID-19, the Impact of the Latest Presidential Proclamation. This has been brought to you by the European American Chamber of Commerce of Greater Cincinnati in partnership with the Cincinnati USA Regional Chamber, the Midwest USA Chinese Chamber of Commerce, the Cincinnati USA Hispanic Chamber, the Japan America Society of Greater Cincinnati, and the Northern Kentucky Chamber of Commerce. So I want to say thanks to all these great partners. Thanks to Matthew and Katie from Frost Brown Todd for sharing your experience. And of course, thanks to all of you for joining us for today's presentation. Just a reminder, all comments and opinions presented by our speakers today are their own and do not necessarily represent the views of the European American Chamber of Commerce or its members. If you want to reach out to Matthew or Katie with additional questions, we will send out a copy of the slide deck, which has their contact information to everyone who registered. We'll also be sending a link to this event on the EACC's YouTube channel. So again, thank you very much for joining us today, and farewell.